In this next series of Law Made Simple, Q&A with Joshua Irvine, we'll dive into everyday legal topics that matter to you. Got legal questions? Joshua has clear answers. Watch this episode to discover how the law works in real-life situations you might face every day.
All right, next question. This is also coming from one of our subcontractors. I have a homeowner that owes me money on our last invoice. It's around $42,000. Why can't I just take them to small claims court?
Oh, wow. That's a big bill. So I guess the first question in there is, why aren't we billing more regularly to allow a bill to get that big? But let's just assume that they were on top of things and they just had a lot of work at the end. This is probably applicable for any business that's owed money of any amount. There are, at least in Utah, and again, every state's a little bit different. In Utah, there are technically 3 courts where you can file lawsuits in order to try to get money back. It could be a contract claim or a collections claim, but there's 3 basic courts: small claims court, and then you have what's called district court. And a couple of years ago, Utah legislature created a new court called the Court of Chancery, or the Chancery Court, which is just a specialized court for business construction or business contract disputes. So you can always take a claim to small claims court if there's a dispute about money. The issue with small claims is you can only go there if it's a dispute about money. You cannot go there to get divorced. You cannot go there to foreclose on liens. You cannot go there, for a lot of those other issues. You can only go there if your ultimate claim is about money. So number one. And number two, you can only go to small claims if you're willing to cap the amount you're willing to claim. And this is true in any state. The amounts are different, but the principle's the same. If you go to a small claims court or a justice court or whatever they call it in your state, it's going to be capped. In Utah, we are capped at $20,000. That changed this year in January, and in a few years it'll change again. But so if you have a $42,000 claim, you can definitely go to small claims court, but your claim must be limited to $20,000. Now, why would somebody willingly walk away from $22,000 in this story? Usually it's because it's cheaper and faster to go to small claims court than it is to go through the whole traditional process of district court. It's faster because the rules are different, they're expedited. It's cheaper, frankly, because the rules are relaxed and you are not required to have an attorney do everything for you. There are a number of my business clients that still hire me to do their small claims case. But even then, because it is very quick and very relaxed, I can give it to them on a very flat fee pricing so that they know up front. So there's just some analysis on that. Usually some people are willing to walk away from some of the money so that they can get it done faster than potentially spending 1 or 2 years and tons of money to try to fight for the whole amount.
Okay.